have is Senate Bill 356, and we're joined by Senator Atkinson. And welcome to Government Affairs.
Thank you, Mr. Chairman, and it's always a pleasure to be back for your committee, a committee I've spent years serving on myself, and I can't say that after watching this room full and your overflow room today that I'm not happy that I'm not on the committee anymore. So, but I have the pleasure this afternoon to come before your committee and present Senate Bill 356 to you and your committee members. For the record, I'm Senator Kelvin Atkinson. I represent Senate District 4 in Clark County. In a nutshell, this bill turns back the clock on collective bargaining to the ways it was in 2013 before the enactment of Senate Bill 241. Before we go over the bill, I think it is important for the committee to understand the seriousness of the unintended consequences of Senate Bill 241. While there's a long list of negative outcomes, I will only mention a few. Perhaps one of the worst impacts was the pay freeze that affected over 1,600 county employees. That's nearly 1/3 of the entire bargaining unit, simply because their anniversary dates fell between June 1st and August 24th. Another unfair result was the need for the union to take the county to court over this decision to freeze or withhold pay increases based on the county's interpretation of Senate Bill 241. While the union won one case and successfully settled another, victory came at the cost of those employees who received lump sum payments, which put them in higher tax brackets, or for those who were never sued, rather the county's retroactive calculations or annual adjustments were done correctly. Finally, the provisions of Senate Bill 241 that made union leave contingent upon concessions at the bargaining table damaged the ability of union leaders to effectively participate in the ongoing negotiations and seemed a bit hypocritical to me. To say the least, since county employees continue to be able to participate while receiving their public salaries. I could go on, but I will turn it over to Rusty McAllister to go over the major provisions of this measure.
Thank you, Senator Atkinson. I don't see any questions. Mr. McAllister, please.
Thank you, Mr. Chairman, member of the committee. For the record, Rusty McAllister, representing Nevada State FL-CIO. I have been asked to kind of go through several sections of the bill here and have at least discuss a little bit about our concerns. I'm in an ironic or a unique position, I guess, because I helped or worked with Senator Roberson in the last session with regards to this bill and tried to at least salvage some of the stuff that we had in the bill, or so that we had already in law, and at the end of the day supported it. We were told, and I was told, led to believe that this would, many of the provisions within this bill would speed up the process. It would speed up negotiations, and it would make that process more timely, and that we wouldn't be in a situation where we were delayed in getting a contract done. And so a lot of these provisions wouldn't really matter because we'd be so fast in getting done that would not be the case. That being said, the exact opposite has happened, Mr. Chairman. In fact, instead of speeding up negotiations, it has slowed down negotiation process tremendously. There is a certain law firm in the state that the day after the governor signed this bill had a letter out to all local government employers saying, here's what you should do immediately to your local government, local employee organizations. And based on the language that's within this bill, and well, we'll just start going, how about we just go through some of the sections here, and I will say right up front, as far as some of the provisions in this bill that talk about teachers and school administrators, I am not the expert on that at all, and I will leave that to others to get up and discuss those issues because they're much more well-versed in those issues than I am. Section 1, Mr. Chairman, talks about that if you have a complaint arises a violation of this bill, the fact-finding process, that if a grievance happens, that the employee, the EMRB, will hear the complaint within 45 days. The EMRB does the best that they can do, but unfortunately they are extremely swamped, and that's not really taking place at this point in time. Section 2, the specific in there is about union business leave. On 2E, the language that's deleted would deal with union business leave, and there's a provision in there in the bill later that talks about union business leave or leave provided. Section 3 essentially is the evergreen clause that's currently in contracts or was in contracts. Again, basically it said before, the contract said that they would continue on until a new contract was agreed upon. This was put in there, I believe, in the hope that this would speed up the negotiation process. The problem was it wasn't the employee organizations that were delaying. It was in many cases the employers. And now that you've taken this out, or that the statute's been taken out of the statute, there's no incentive for local government employers to negotiate. Why would they? For every day that they delay, they're saving money. They don't have to pay raises. They don't have to pay longevity. They don't have to pay anything. They're saving money, so they drag it out, extend it out for an extended period of time. There's no incentive. Steps are stopped. Steps in merit pay increases, longevity, promotional raises. People who get a raise during the time or get a promotion don't get the raise even though they get the job. And if they're delayed a year or 2 years or however long before they have that promotion, they never see that promotional increase. And there's no provision in here for retroactivity for it to go back and be retroactive to the time that they got promoted. So they're just out that pay. Sections 4, again, 4, 5, 6, these all, 7, almost all of them beyond this deal with school administrators and school teachers and their probationary periods, how much salary they can or cannot make. I did talk to the lobbyist for the school administrators. He stated that they have another bill that they're working on that they believe would be much better language than this. It doesn't tie it to a financial number as much as it ties it to either a specific job duty or job specification, which is a much clearer provision than a salary. With that, Mr. Chairman, the other issue that's in the bill deals with union business leave. Senator Roberson was gracious enough to allow us to amend that part of it that said that we could, if you gave up a concession equal to the cost of union leave, that you could have it. Well, during the negotiation process, everything has a dollar cost value. There's nothing that you negotiate for that the local governments don't say, if we do this, this is how much it costs and how much are you willing to give. So for those who already had union leave in their contracts prior to this, they had already given up a concession because nobody gets something for nothing. And so that's why we asked to have that negotiated in or amended in so that those who already had it in their contract had already negotiated for it and given up some concession in some form or another. Since then, many government employers have said, no, that's not the case. That's not how we interpret that. We didn't, you've got nothing that shows you gave up something. But again, nobody gets something for nothing. In the negotiation process, there's always something you have to give up to get something. So this would remove that provision and put the union leave abilities back into the statute. Mr. Chairman, if there's any questions that I can answer on the parts that I'm more privy to, I'd be more than happy to try.
Thank you, Mr. McAllister. Questions from the committee? We'll start with Senator Gokachia, please.
Thank you, Mr. Chair and Rusty. I guess all right, we deleted that piece in there that required the 45 days, I believe, just in section 1, starting into the bill. and not kind of, now we've rolled back to 180 days. Is that correct? The board may hear and determine any complaint arising.
Thank you, Mr. Chairman. To you and to Senator Goycochea, Rusty McAllister, for the record, yes, this would go back to the original language of 180 days. Again, the NLRB is not hearing them in 45 days as it is. Not, in many cases, these are getting, I can tell you one grievance that was filed on our, with regards from the local that I belong to, has been, it was over 6 months and still had not been heard. It kept being postponed off and on.
Okay, and I just kind of remember from the last session, we thought that was going to be a bonus again, if we could get them to hear them, move them ahead quicker. But now it seems, now we're going back and, unfortunately, if you got 45 days and that's kind of the deadline you're trying to meet, but now we've moved to 180, so we're 6 months out, and then we're going to start talking about postponements and we can't get there. It looks like it's going to make it longer yet. So just my point. All right, thank you, sir. Thank you, Mr. Chair.
Thank you, Senator Goycochea. Further questions from the committee? I'd just simply like to confirm what Mr. McAllister said, that during my years with the city of Las Vegas, I served on the negotiating committee, and we went through some pretty lengthy discussions as to what the value was of union leave or leave from duties for negotiated purposes, and a price tag was determined for those having the availability of those hours for handling union business. So, thank you. Okay. Would you like to? Okay. Good afternoon and welcome.
Good afternoon, Chairman Parks, Vice Chairman Menendo, and members of the Senate Government Affairs Committee. My name is Michelle Kim, and I represent the Clark County Education Association, and we represent 18,000 educators and licensed professionals in the Clark County School District. Currently under NRS 288-155, as amended in the 2015 legislative session under Senate Bill 241, if a collective bargaining agreement expires, a local government employer is not required to pay any compensation or monetary benefits under the collective bargaining agreement until a successor agreement becomes effective. The arguments I heard in the 2015 legislative session to support the elimination of evergreen was namely around, obviously, what Mr. McAllister mentioned regarding dragging their feet, delaying the collective bargaining process. But there was another argument with regards to the fiscal cost that this would potentially have on employers. And while I can understand and there could be something said around that argument, I do agree with Mr. McAllister regarding the experience regarding speed. However, for Clark County Education Association and its educators, there's an even bigger issue. In the 2015 collective bargaining school year, the Clark County School District and the Clark County Education Association negotiated a new compensation structure, and it's called the Professional Growth Plan. And I have put it up on Nellis if you guys want to take a look at it. Under the new salary schedule, there are no automatic advancements on columns. Rather, teachers are on either a 2, 3, or a 4-year track. So people, to be eligible for a 2-year track, you have to work in a Title I, Tier 1, Tier 2 school. Otherwise, you're on a 3-year track. And what that means is that no educator can move more quickly. They have to wait, and they have to work at those schools. And not only that, they have to acquire 225 contact units. And the contact units are approved based on a plan that's collaboratively developed between an educator and their supervisor. And this also aligns not only with their growth plan, their career pathway, but also the Nevada Educator Performance Framework. So in short, what I'm saying is these educators are investing a lot of money and a lot of time over many years to get a certain salary increase. Because of this bill, because of the 2015 legislative change, a teacher can invest thousands of dollars, work for multiple years at a Title I, Title I, Tier 1, 2 school, And then when it comes time for them to get their advancement, they may not get it. And this is a serious problem for educators. They'll be disincentivized in ever making an investment in lifelong learning to the community, to their students, if they don't feel that the promise will happen. And I hear it all the time from educators who don't believe that they're going to get their advancements. So, I mean, in that regard, I sort of mimic what Mr. McAllister was saying with regards to there's no incentive for an employer to be motivated in finishing the negotiations early. Not if there's about 10,000 educators who are promised after 2, 3, 4 years a column advancement and they don't need to give it to them. And we've had that problem in 2015 after the legislative session where there was a freeze on all educators. And you know, it's very important that educators and licensed professionals know that they don't lose what they've earned, what they've invested in terms of increases in investments because a collective bargaining agreement has expired. And I do hope that the legislature encourages educators and licensed professionals in engaging in lifelong learning to ensure that all Nevada schools students can succeed. Thank you.
Thank you, Ms. Kim, for your testimony. Questions from the committee? Okay, I'm not seeing any.
Thank you.
Senator Atkinson, did you have? Oh.
Okay, that's all.
Yeah,
You will
okay.
hear a friendly amendment from Marlene on the behalf of the Public Employees Labor Caucus, and it is acceptable.
Okay,
Okay.
thank you for that.
Thank you.
Okay. In Las Vegas, if there's anyone who'd like to speak in support of Senate Bill 356, if you could make your way to the table, we'd appreciate hearing from you. Otherwise, we're going to continue here in Carson City, and okay, Mr. Callis, oh my God. Mr. Dreer, please proceed.
Thank you, Mr. Chairman and members of the committee. For the record, Ron Dreer, representing the Peace Officers Research Association of Nevada, the Reno Police Protective Association, the Law Enforcement Coalition, and the Washoe School Principals Association. We are asking you to support SB 356. We stand by the comments you heard by Senator Atkinson and thank him for sponsoring this, as well as Mr. McAllister and the people from CCEA and those comments that you'll hear down here. It's a situation that I have been part of for many years as to watch the collective bargaining process work. And since 2015, it hasn't worked. It's slowed the process down. There has been a lot of money made for a certain law firm in this state, and Mr. McAllister has the facts on that support that. I know the city of Reno paid out over $1 million to one law firm specifically, and over the past couple of years, they've paid out over several $100,000. The purpose of collective bargaining is not to bog the system down, but to reach an agreement over a period of time as short as possible. And if you can't do it within those parameters, then you go through the resolution techniques provided in NRS 288. With the passage of SB 356, we can actually go back to the table and start doing things. People that were denied step increases will probably finally start getting them again, as well as the other compensation benefits. And to address the issue that Senator Gokachila brought up again on the MRB, having gone through the MRB a lot, they are and have legislation proposed, as you know, because Friday you heard the bill on SB 460, that would expand that board to 5 from 3. That would help that process. So by extending this to 180 days, that really helps them again to get the job done that we're asking them to do. So with that in mind, we're asking you to support SB 356. Thank you very much.
Thank you, Mr. Dreer. Questions from the committee? I'm not seeing any. Good afternoon.
Mr. Chair, committee members, Chris Daly, Nevada State Education Association, representing 40,000 teachers and education support professionals across the state, working to ensure high-quality public education for every Nevada student. As Nevada's largest public employee union, we appreciate the significant benefits of a fair, collective bargaining process. NSEA supports SB 356, which strengthens collective bargaining provisions for public employees. We also support an amendment that was previously referenced to include clarifying language on leave provisions. During the 2015 session, changes made to NRS 288 created burdensome timelines on the selection of arbitrators for both employers and employee associations representing teachers and education support professionals. Changes made also gave economic incentives for public employers not to reach agreement with their bargaining unit. SB 356 addresses these issues and would set a more reasonable and more level playing field for collective bargaining. Meanwhile, many employee associations have had trouble having a complete bargaining team without getting leave for contract discussions. NSEA supports language suggested by the Public Employee Labor Caucus to clarify these leave provisions to help alleviate this issue. Thank you.
Thank you, Mr. Daly, for that. Ms. Mancini, good afternoon.
Good afternoon, Chair Parks and members of the committee. Sherry Mancini, President, SEIU Nevada. SEIU Nevada represents about 10,000 public sector employees across Las Vegas Valley, making us one of the largest public sector unions in the state. Half of those are employees of Clark County who were adversely affected by the unintended consequences of SB 241 from the 78th session. Today, we rise together in support of SB 356. The intention of legislation passed last session was to speed up the process of public sector collective bargaining and save taxpayer dollars. Instead, the opposite occurred. The bill created a perverse incentive for a public sector employer to drag and delay its feet at the bargaining table. For the employer, every day that goes by without a signed agreement means more money they save off the backs of working families. Those employees with a hire date falling between the expiration of our contract with the county, about 1,600 in total, had their hard-earned raises and step increases unjustly held due to no fault of their own. And I received quite a few. I had to deal with the aftermath of this, and it was an incessant calling, texting, emails from people who were so upset at their jobs that I don't know how productive they were even at their jobs, because they were so wrapped up in, am I going to get my raise? What's going to happen? And it was harmful for the taxpayers as well. Proponents of that bill will say that the public employer not paying its workers is a boon to the taxpayer, but they ignore this is the ripe opportunity this legislation created for attorneys seeking to make profit off the exploitation. I know that there's been quite a few references this morning in regards to a law firm that sent out a bill. I want to enter this into record, which is the actual email that was sent out, which is dated June 2nd from Mark Ricciardi, which basically breaks down the bill and if your CBA is in effect right now, what you should do, and also if your CBA is expired, what you should do. And please, this is just general advice. Please feel free to contact me with any questions specific to what you need to do if you are coming up for collective bargaining. So I would like to enter that into record. So that letter was essentially step-by-step how-to guide on how to undermine public employees' wages and benefits. Mr. Ricciardi concluded this letter by offering his expert legal consultation to any local government wishing to go down that road. Once our contract with the county employees had been signed and our union stood together to ask that those affected working families be made whole, their employer saw fit to hire Mr. Ricciardi and other attorneys to fight their employees. We, the taxpayers, footed the bill for this lengthy and costly litigation. We've put in a public request to Clark County to get the financials of what the taxpayers' bill was for this litigation, and we have as of yet to be able to get that money. I know SEIU minimally came out of pocket close to $100,000. We agree and support the notion that labor organizations ought to be held accountable for bargaining in good faith. We also expect the employers to be held to the same standard. As taxpayers of the state, we all support and agree with the idea that our tax dollars ought to be spent responsibly, but we also feel strongly that the primary beneficiaries ought to be the hardworking men and women who fix our highways, maintain our airports, manage our foster children, and provide clean drinking water. It should not be the benefit of high-priced lawyers seeking to profit by helping employers skirt a collective bargain agreement. This law created many unintended consequences for the county and for SEIU members. SEIU and the county eventually reached a settlement to pay back but not without great and unnecessary expense to both sides. To calculate retroactivity for 1,600 employees was as much a logistical nightmare for the county payroll as it was a financial headache for our members who finally received their withheld raises in a large lump sum just before tax season. We urge this committee and this body to do right by working families of the state and pass SB 356, which strikes from the NRS sections which created this unfair and detrimental condition for collective bargaining. Thank you. Any questions?
Thank you, Ms. Mancini. Questions from the committee? I'm not seeing any. I don't know who was next, Mr. McCann
Thank you,
or
Mr.
Mr.
Chair.
Ramirez. Okay.
Thank you, Chair. Members of the committee, Mike Ramirez, representing the Law Enforcement Association and their 8,000 members. We'd like to thank Senator Atkinson for bringing this forward. Also, thank Mr. McAllister for going through the bill. We mirror the same comments as Mr. McAllister brought up, the concerns. And we also support the amendment that Ms. Lockhart has for this bill, and we urge the committee to support 356.
Thank you, Mr. Ramirez. Questions? Okay, I'm not seeing any.
Good afternoon, Mr. Chair, members of the committee, Rick McCann, Nevada Association of Public Safety Officers, and also a member of the Statewide Law Enforcement Coalition. Thank you to Senator Atkinson and the co-sponsors for offering this bill. We do, in fact, support SB 356. I will tell you on the record, NAPSO, my organization, did not support SB 241 last session. Matter of fact, I testified directly in opposition to it. But we certainly are here to support this one because we think this is the fix we've needed after 2 years of observing something that was not intended, but happened, and now we're going to try to fix it. And that's what we come. That's what we come here every 2 years to do, to look at new stuff and look at the old stuff and see what's happening, what's fixed, what needs to be fixed and what doesn't, and that's why we're here. The consequences of 241 last session have resulted in unexpected delays, protracted litigation over the issues, non-existent time for our employees to meet and bargain over their contracts. See, the whole purpose of 241 last session was to get people to the table. It has had the exact opposite effect. And in 2 years, we figured that out, so we're here to see if we can fix it. Just an example I'll leave you with. I mean, you've read the bill. You know what it is. You know what the 241 is. You and I contract, and I'm going to give you something. We decide, a little quid pro quo, you give me something, I'm giving you something this year. And you know what? Our contract says I'm going to give you the same thing next year, and I'm going to give you the same thing the third year. We've contracted for that. We've agreed to that. You gave me A, I gave you these things over the next 3 years, and we're going along merrily. Things are great. Then all of a sudden, 241 came into our lives and said, oh, you still want what I said I was going to give you? You got to give me more. You say next year you want what I'm going to give you? Got to give me some more. I'm making you renegotiate and give concessions and give me more for things we've always contracted for. That's the basics of this whole thing. Nothing more, nothing less. That is unfair. You would not be happy about that. All we're trying to do is fix it. Every 2 years we get a chance to fix stuff that didn't go right. That's all this is. We're not just trying to repeal and roll back and all those things. We're trying to fix something. And this bill, SB 356, does exactly that, and we wholeheartedly support it. Thank you.
Thank you, Mr. McCann. Questions? Okay, I'm not seeing any. Mr. Dunn, welcome.
Good afternoon. For the record, Tom Dunn, representing Professional Firefighters of Nevada. We also sit here in support of SB 356. There are a lot of unintended consequences sometimes when it comes out of legislative sessions, and we feel that SB 241 from the last legislative session definitely harmed a lot of our smaller locals that we represent, locals such as Mount Charleston Fire District. You've got a local that has under 20 people that's trying to negotiate a collective bargaining agreement. However, on the other side, there's a $400 an hour attorney and a law firm sitting up against them. So, you know, collective bargaining is supposed to level the playing field between the employer the employer and the employee organization. SB 241, in our opinion, did not do that. So we respectfully sit here in support of SB 356 as well as Ms. Lockhart's amendment.
Thank you, Mr. Dunn. Questions? Yes, we have a question for Mr. Dunn. I believe there's a question from Senator Hardy.
Is this the amendment that you're alluding to?
No, sir, there's not. Ms. Lockhart has one that she, I believe, submitted to Nellis.
Okay.
We don't have it.
Yeah. I'm not aware I was going to. Thank you, Mr. Dunn. Ms. Luckard, I don't, was that submitted for Nellis? Do you know? Oh, okay. Well, we'll verify that. Okay, thank you. Okay.
Kent
Good afternoon.
Irvin.
Welcome.
Oh, thank you, Senator Parks and committee members. Kent Irvin, representing the Nevada Faculty Alliance and representing the collective bargaining units at 3 of our community colleges through our organization, the American Association of University Professors. This bill doesn't affect us directly, but we just stand in solidarity and support for it. Thank you.
Thank you, Mr. Irvin, for that. Is there anyone else who'd like to speak in support of Senate Bill 356? Okay. Is there anyone who'd like to speak in opposition to Senate Bill 356, if they'd come forward, either here or in Las Vegas?
Good afternoon, Mr. Chairman. For the record, Trey Abney, today representing the chambers of Reno Sparks in Northern Nevada and also the Las Vegas Metro Chamber of Commerce. I want to thank Senator Atkinson for chatting with us last week about this bill. He stated that he already knew we were going to be opposed to it before we ever walked into office. But I appreciate him taking his time to chat with us. I spent a lot of time with you on this very issue last Friday afternoon for several hours, so I will make my comments brief. 3 main things we're concerned about here. First is the evergreen clause piece. We do think that a contract should end, and that when it does end, it doesn't mean people stop getting paid, but they're paid the same amount that they were paid. There's no incentive for the labor, on the other side of the coin, there's no incentive for the labor unions to come to the table if a contract does not have an end date. Now, I will throw Mr. McAllister and supporters of this a bone as far as a new position or something like that. I think that is something that needs to be talked about. If you are promoted into a bona fide new position, I think that's something that could be addressed here. I mentioned on Friday our concern with supervisory unions. The Chamber, of course, have always been opposed to allowing people in supervisory roles to unionize at all. So that's our second issue. And then finally, this whole idea about paid leave, always concerned about taxpayers paying for employees to do union business on taxpayer time. Now, if they're provided leave and the government does not have to pay for that and the union pays for it, or they take time off, I think that's a different situation. But I think that language needs to be clarified, that taxpayers will not pay for employees to do union business on their time. And that's all I have, Mr. Chairman. Thank you very much for your indulgence.
Thank you, Mr. Abney. Questions from the committee? Okay, I'm not seeing any. Thank you very much. Mr. Henderson?
Thank you. Good afternoon, Chairman Parks, members of the committee. For the record, Wes Henderson with the Nevada League of Cities and Municipalities. A wise man once said, deja vu all over again. And that's pretty much where we are. I recognize this bill from last session, but all the language in here that's red now was blue last year. And we think that some changes were needed to the collective bargaining system. This bill may have gone too far. We don't know. There may be some parts that need amended this session. But we also think that it may be premature to come in and totally undo what was just done 2 short years ago. Thank you.
Thank you, Mr. Henderson. Questions from the committee? I'm not seeing any. Thank you. Ms. Rourke?
Thank you, Mr. Chairman, members of the committee. Nicole Rourke, representing the Clark County School District. While there are several things in the bill that we actually do support, the return of the evergreen clause in Section 3 is why we're here in opposition today. We feel like defined dates for agreements assist us in the budgeting process, as well as, there's always an issue when we pay advancements for employees and then something else is negotiated and then we're in a payback situation. So for those reasons, we're here in the opposed position. Thank you.
Thank you, Ms. Rourke. Questions? I'm not seeing any. Thank you. Is there anyone else either here? Oh, we have somebody in Las Vegas. If there's anyone else here in Carson City who'd like to speak in opposition to Senate Bill 356, we'd have to ask them to come to the table. We'll go to Southern Nevada. Welcome.
Thank you, Mr. Chairman, members of the committee. Scott Davis from, Scott Davis from Clark County. Clark County is opposed to the bill, to SB 356. That's based on a couple of sections of the bill only. Section 3 of the bill, the one that would revert back to the evergreen provisions, back to the status quo that had existed where collective bargaining agreements, even those that had expired, would just continue in perpetuity while a new one was being negotiated. You recall that when these changes were adopted last session, they did receive a broad spectrum of support from labor as well as from management, and that's because they were intended to eliminate that negotiations treadmill, those long-running negotiation sessions that don't generate an agreement. It was intended to bring the parties together, get them to roll up their sleeves, get down to business, come together and work out an agreement. And in the experience of Clark County, it actually works. It has produced generated positive results in negotiations. It has sped up the process. It has generated higher quality negotiation sessions. The parties have come to the negotiation sessions focused, ready to get down to business. And just by way of an example, for agreements that have kicked off new negotiations since SB 241 was adopted last session, there have been 4 bargaining units where that's been the case: the Firefighters Battalion Chiefs Union, the Juvenile Justice Peace Officers Association, the Firefighters Rank and File Union, and the Deputy Sheriff's Association. Each one of those negotiations were begun and completed in a timely manner such that the proposed agreement was presented to the Board of County Commissioners in June for approval before the start of the new fiscal year. So for each one of those units, we began the new fiscal year with a contract already done, already approved, and already in place. We've also, during the last fiscal year, had 6 fiscal reopeners that had to be negotiated. Each one of those was done and wrapped up in June and approved by the Board of County Commissioners before the start of the new fiscal year. So it's been the experience of Clark County that those provisions that are currently in the law that are being targeted by Section 3 of the bill actually do speed up the process. They do generate results that are meaningful. And when you're in the place of the county and you have a multitude of unions with which the county must negotiate, it's very important to be able to have those meaningful negotiation sessions and to have those agreements in place at the start of the new fiscal year. You've heard about the logistics that go into calculating retroactivity. That's avoided if a new agreement is in place. One point to note is that retroactivity is always something that's subject to negotiation. That's guaranteed by NRS 152Q. So that's retroactivity is something that's always on the table. Since the current statutory language does result in quality negotiations, it has generated timely agreements. It would not be prudent to retreat from that position at this time. The county is also opposed to Section 1 of the bill. That's the language that would target the expedited procedure in front of the EMRB. This is an important provision because it works in tandem with the language in Section 3 of the bill to bring the parties together and to provide an incentive for both parties to negotiate the agreement. It's really not correct to say that there's no incentive for the employer to negotiate, to drag their feet. Because if that's the case, if an employer is negotiating in bad faith, it will come back to bite them. There's provisions in NRS 288, 200, 215, and 217 that bring that into play in the event of fact-finding or arbitration. So it will come back to bite the employer if they are just dragging their feet. And I think one other point to note is that some of the horror stories that you've heard are really an aberration. They're a one-time event that came into play because there had been long-running negotiations that had begun before the amendments were adopted, and there were a lot of legal issues to be worked out, such as retroactivity of SB 241. Those have been resolved, and those won't be an issue going forward. So the county is opposed to those 2 portions of the bill. Thank you.
Thank you, Mr. Scott. Questions for the committee? Okay, I'm not seeing any. Okay, thank you once again. So is there anyone else who would like to speak in opposition? Last call. Okay.
Mr. Chairman and members of the committee, for the record, Jeff Fontaine, representing the Nevada Association of Counties. We just wanted to echo the comments made relative to Section 3 and the removal of the evergreen clause, or restoration to the evergreen clause that was removed in the prior session. You heard comments as to why we think that should remain from last session, give it more time to be worked out, and if there are adjustments that need to be made, such as promotions and things of that nature, I think those are reasonable. But to go back to the way it was in the past, we think we need more time before we make that judgment and restore that.
Thank you, Mr. Fontaine. Questions? I'm not seeing any questions. Okay. Finally, is there anyone who'd like to speak in the neutral on SB 356? Ms. Bowen, good afternoon. Welcome.
Good afternoon. Hadn't planned to speak on this bill, but I thought it was important. My name and my words for the record, P-E-G-G-Y-L-E-A-R-B-O-W-E-N. I was a member of the Washoe County Teachers Association and made the motion to that entity that I didn't care how long it took them to negotiate the contract after we'd gone through prolonged contracts for a period of time, as long as the contract went back to the start of the contract date. And as a result, all of a sudden, we had a contract in a relatively short period of time where good faith was shown, and that as long as we didn't get paid anything on the newly negotiated contract until it was negotiated, and it wasn't retroactive, that they were prolonged. And when we said, and the motion passed by the way of Rep Council unanimously, that in fact that negotiate for however long you want, just have it go back to the beginning of the school year, is what we were basing that on as the employees, the contract for the school year. And all of a sudden it sped up the process, and it seemed like it was being done in better good faith. Thank you very much.
Thank you, Ms. Bowen. I don't see any questions. Appreciate it. Thanks. Okay, if there's no further testimony, we'd ask the sponsor of the bill to give us final comments.
Thank you, Senator, Mr. Chairman. I was just getting my notes out real quick. I've been around quite some time, and 15 years to be exact. And what I do know is that we sometimes have measures in this building that we think are good things, and sometimes they have unintended consequences. And we have to come back to the legislature to either fix them, change them, modify, or what have you. I believe this is one of those circumstances, committee members. I believe there has been some unintended consequences where we thought we were fixing some things as a body, and some things did get fixed, no doubt about it, but there were some things that were severely damaged. Folks will talk about the evergreen clause. They will talk about promises made last session, promises made, promises kept. You can't keep a promise on a bad deal. This was a bad deal, and it should be fixed. And if we as a body put this in place and it was imperfect, we as a body should do something about fixing it. The Clark County school administrators, they're going to salary arbitration for the first time ever. And their contract expired July 2015. By the time we leave here, we'll be close to 2 years if this matter isn't resolved. So don't tell me that it's made it better. Hasn't made it better. We're talking 2 years, and so if I'm remembering this correctly, SEIU also is at impasse. So these things haven't been made better. They have been made significantly worse. And so, again, we have an attorney out there who sought to capitalize on this situation, and has taken if I have seen these numbers correctly, and hopefully they're public record, and will be at some time be shared to the committee. But they're running around acting like, no disrespect, any trial lawyers in here? They're running around acting like trial lawyers, and not that trial lawyers are bad, but they have a job to do, and they serve clients who are injured or need help, et cetera, et cetera. And so they do what they have to do to make sure those clients know that they're available, and that is what happened in this case. And so I think that we have the opportunity as a body to take a look at this measure, take a look at the bill, to take a look at, I know Evergreen's an issue. I know the union leave stuff is an issue. Certainly what happened to all those county employees is an issue. I don't need to disclose that I'm a county employee because I'm not anymore. I retired in February, but I do know the damage that occurred. And so I hope that the committee will seriously take a look at this issue. And I will certainly make myself available if we need to have some further discussions. I know deadline is an issue coming up this week, but I hope that we can seriously take a look at this issue and not leave this as status quo while we continue to hemorrhage. That's all I had to say, Mr. Chairman, and I hope the body will look at this favorably. Thank you.
Thank you, Senator Atkinson. Any comment, final questions? No, we're not saying any. Once again, thanks for bringing this bill forward. Okay, with that, we're going to go ahead and close the hearing on 356.